Hi everyone, this lecture is about constitutional limits on criminal law. It's based on Chapter 2. As I mentioned in the pre-recorded lecture for Chapter 1, from here on out when we talk about the chapters, we're not going to cover the cases in the pre-recorded lecture. Those are going to be the topic of discussion in the in-class session. So please make sure that you have fully read the chapter before attending class and are prepared to apply this information. So this chapter is going to talk about some of the limits that the Constitution places on the law. Let's start by talking a little bit about the Constitution. When the Constitution was drafted, the Founding Fathers were concerned about how much power government officials would have. They wanted us to have individual freedom without much governmental interference, but at the same time, they want to provide order and safety for everyone. So the Constitution is a balance of government power and individual liberty. We live in what's called a constitutional democracy. So the majority, right, so the majority in terms of legislators or the people, can't make a law against the behavior that the Constitution protects as a fundamental right. So, for example, in the First Amendment, there's a prohibition against the government infringing upon free speech. Okay, so even if the majority wants a law that infringes upon free speech, you can't make one. So this limits the power of government to create certain crimes, and there are also state constitutions that also limit government power. Rule of law is a concept that no individual is above the law. What does this mean in practice? It means that government officials can't pass laws that conflict with the Constitution. The Constitution is the ultimate law of the land, and it trumps all other conflicting laws. Now, in reality, in practice, laws are passed all the time that do not pass constitutional muster. What happens then is somebody is able to appeal a conviction under that law, and we would see new rulings from the Supreme Court as to what constitutes or what they would interpret the law to determine for us what the actual, how the Constitution would apply in a particular situation. So what principle we want to think about that places limits on the law is the principle of legality. So there could be no crime without a law and no punishment without the law. And we talked about this a little bit in Chapter 1. So the law has to dictate what behavior is illegal and what the punishment for that is. So if today you engage in some behavior that tomorrow becomes illegal, you can't be punished for engaging in that behavior today. This means that we might let somebody that we consider to be blameworthy or accountable morally to not actually be legally accountable. So in 1994, we've got this case, Hughes v. State. And Trevor Hughes, during a DUI, kills the fetus of Poole, a woman whose car he hit. She was due to deliver in 4 days, and he appeals his case, and the appeals court reversed his conviction. They said that there was no law in place at the time that dictated that an unborn fetus would be included in a homicide statute, and therefore he cannot be held accountable for breaking that law if he doesn't know that law exists. And we'll talk a little bit more in the chapter on homicide about how we can potentially punish people for killing an unborn child, for killing a fetus. So why don't we apply laws retroactively, right? Why not pass a law today and then turn around and punish Hughes for that? Well, this undermines the value of society. Knowing what the law tells us to do provides us with the opportunity to obey the law. It also promotes autonomy and dignity. And it prevents people from punishing someone for behavior they just don't like. And you know, this kind of comes back to this concept of rule of law, right? So as opposed to, you know, how other countries ruled hundreds of years ago, where a ruler could just decide because he doesn't like somebody or he doesn't like what somebody did that they're going to be punished criminally for that. We also have a ban on ex post facto laws. Ex post facto means after the fact. Okay? So this principle is in Article 1, Section 9, and ex post facto bans Congress from retroactive criminal lawmaking. And states have similar provisions within their constitutions. So we cannot punish somebody for behavior they engaged in or committed in the past for which there was no law at the time. So for instance, I couldn't make it a law tomorrow that you cannot chew bubble gum and then punish you for chewing gum last week. Ex post facto laws do one of three things. They criminalize a behavior that was innocent when the person committed it. This is the clearest example, but it's also not very common. Also along these lines would be the change in elements of a crime. So statutory rape laws say that when a person is under a certain age, they cannot consent to sexual intercourse. If I were to turn around and raise the age for that, I couldn't then punish somebody. If tomorrow we were to change the age in Massachusetts to 17, I couldn't punish somebody who today had sex with someone who was under the age of 17. They might also increase punishment for a crime after it was committed, and that's more common, or it might take away a defense that was previously available to a defendant when they actually committed the crime. Why do we have a ban on this? Two big reasons. We want to make sure that people have fair warning about what is illegal behavior. And we want to make sure that the legislature doesn't pass laws arbitrarily or in a vindictive fashion. So far we've got legality, ex post facto laws. Laws can also be considered void for being vague. We want to make sure that a law is pretty clear about what behavior it's prohibiting, okay? Vague laws violate two provisions of the Constitution, the 5th and the 14th Amendment. The 14th Amendment simply makes the 5th Amendment applicable to the states and not just the federal government. So the 5th Amendment says the federal government shall not deny any person life, liberty, or property without due process of law. So if you guys remember in CJ 101, we talked about due process. Due process is sort of the rules of the game. Right, that there are rules as to what happens when someone is arrested, when someone is charged with a crime, and before we take away someone's life, property, or their freedom, we have to make sure we follow those rules. So any law that's vague makes it difficult for us to know what we're supposed to be doing. So how does it violate due process? As we mentioned, 5th and 14th Amendment bans anything that violates due process. Criminal punishment does deprive people of life, liberty, or property, and we want to make sure that that is not defined arbitrarily. So this doctrine, voiding a law for vagueness, takes aim at two things. Void laws don't give someone fair warning as to what is prohibited, and when they're vague, it allows officials to sort of broaden the definition of the behavior, and it may allow for either discriminatory law enforcement or arbitrary law enforcement. So the Lanzetta case in 1939 challenged this law based on vagueness. This was looking at people who were members of a gang, and the law, which we can see here in italics, said any person not engaged in any lawful occupation known to be a member of any gang consisting of 2 or more persons, who has been convicted at least 3 times of being a disorderly person, or has been convicted of any crime in this or in any other state, is declared to be a gangster. Every violation is punishable by a fine. So I mean, look at that law. Is it really being very clear about what constitutes being a member of a gang? If you guys were to think about it today, take a moment and think about how would you define a gang, how would you define gang membership? So here they're saying anybody engaged in any, not engaged in something lawful, and a gang consisting of 2 or more people. The trial court threw out the challenge, and then the Intermediate Appellate Court and New Jersey Supreme Court threw it out, but this case made it to the Supreme Court. The Supreme Court ruled unanimously, so all the justices voted the same way. And it says that no one should be required to guess as to what a statute means. If people of common intelligence have to guess at its meaning or differ as to its application, then it violates, then it's too vague. So again, if we were to flip back to this, would you be sure if your behavior was violating the law? So if 2 or 3 of you were up in the Boston Common and you were doing drugs together, would that make you gang members? Is it clear? Are we sure that this is what this definition is looking at? So basically, Lanzetta says that there has to be a fair notice requirement, and that this is an objective test. Would an ordinary, reasonable person know that what they were doing was criminal? In 1983, the court held that providing minimal guidance to limit arbitrary discriminatory discretion is more important than the fair notice aim, and that's a primary aim there for being void for vagueness. We want to make sure that there's guidance to the law that is pretty clear to us what behavior is illegal. There's always going to be some uncertainty in the law. Courts allow quite a bit of leeway when they look at cases and determine if they're vague. Look at the Constitution and how these laws are, how the amendments are written. They're also written in a way that's vague to a certain degree, and that allows the law to change over time and be more flexible. So we can't predict any variation of something that might happen. So if you think about laws today, right, there are constantly new sort of designer drugs being developed. We don't necessarily have laws that ban them. So some laws have been written that talk about substances with a similar chemical makeup. But we can't anticipate everything that could happen. If you are wondering, is the statute vague or not, it's, you should assume it's not vague, right? So there's a presumption that the law is constitutional. Actually, if you want to argue that a law under which you were punished is vague, then you have to prove the law is vague. So you have to show an individual of ordinary intelligence would not understand what you were required to do, and you have to prove that beyond a reasonable doubt. So you think about it, that's a pretty high threshold to meet. It's going to be pretty difficult to prove that. Okay, so we've got legality, we've got void for vagueness. And what was the third one we talked about? Ex post facto. So now we're going to talk about equal protection under the law. This is a clause in the Constitution, and it's generally more of an issue, not so much with what the law bans or how, but rather how, with criminal procedure, how people are arrested, how they're prosecuted. It doesn't mean everybody has to be treated the same, but if you're going to have different treatment for different groups of people, you have to have a rational basis for that different treatment. So oftentimes we treat minors differently than we treat adults. And we have a rational basis for that. We believe that minors don't understand the consequences of their actions as well. And so we allow them to be treated differently. That rational basis is generally tied into the state's interest in maintaining the public health and welfare of the citizens of the state. So we're often looking at police powers of the state. Federal government doesn't have police powers, so Congress has to tie its legislation to some power that it has in the Constitution. That could be the ability to regulate contracts, to regulate interstate commerce, right? So that's how business is conducted between different states, which is pretty cool. So if we look at a class of people and they're being treated differently under the law, and we want to figure out if there's a rational basis for that, we generally, if it's not what we call a suspect class, then we give it normal scrutiny. So as long as the state has a rational basis, then it doesn't violate equal protection. So here's two examples, right? We take habitual offenders, people who have offended, broken the law multiple times, more harshly than first-time offenders. And there's a rational basis for that, right? If you haven't already learned your lesson or conformed your behavior in the past, then we might treat you differently. Also, treating minors differently than adults for the purpose of possession or consumption of alcohol, right? So we consider that to have a rational basis. Although I know many of you who are between 18 and 21 might disagree with that. There are certain classifications of people that are now subject to strict scrutiny, okay? So if we change the law based on someone's race and we say people who are Black or people who are Hispanic are going to get a harsher punishment than people who are white, that's not justifiable, right? We can't show a compelling reason to punish people from a different racial category more harshly. So we look at this as strict scrutiny. We're going to look at those laws much more closely. Gender falls somewhere between strict and rational and falls under what we call heightened scrutiny. So states have to show a fair and substantial relationship between changing the law based on gender and some legitimate state end. So a little bit higher threshold that people have to cross. All right, so the Bill of Rights. What does the Bill of Rights do? How does it affect criminal law? The Constitution was passed, and the Founding Fathers had some concerns immediately, so the first 10 amendments are passed as the Bill of Rights. The more criminal justice courses you take, the better you'll get at knowing these sort of not word for word, but knowing what the First versus the Fifth Amendment is. So the First Amendment is kind of the best amendment, mostly because it's got multiple rights in it that are pretty important. Free speech, freedom of religion, and freedom of association. It also has freedom of the press as well, okay? So what does that mean? We can't make a crime out of behavior that exercises our rights to free speech, free religion, free association, okay? In practice, this means a lot of different things. So Congress, the government cannot limit your free speech. So you guys might recall that recently in the news, not really, the news, but the media had been reporting on one of the guys that was on Duck Dynasty had said some offensive comments. And A&E banned him from the show for a while. I saw a lot of people on Facebook writing comments, what happened to free speech? Well, first we have to understand what free speech means. And free speech means the government cannot limit your speech before you say it. Okay? So A&E is not the government. A&E is a private entity. They can limit speech if they want to. Okay? Speech does not just refer to spoken or written words. It includes expressive conduct. So that could be protesting. It could be wearing a symbol of something. It also includes symbolic speech and to some extent commercial speech. So there are some categories of speech not protected by the First Amendment. So obscenity, right, which is actually pretty hard to define and legally has not been defined well by the Supreme Court. The Supreme Court has sort of said, I know it when I see it. But obscenity is material that has a predominant appeal to nudity, sexual activity, or excretion. So excretion refers to like, peeing and pooping. Profanity, irreverence towards sacred things. Libel and slander, this is when you lie about somebody. Libel is done in print, slander is spoken. So if I took out an ad in the Boston Globe and I alleged that a particular person was a sex offender, I could be sued for libel. Fighting words, these are words that are likely to provoke the average person to immediately retaliate and cause a breach of peace. And anything that creates a clear and present danger of evil above public inconvenience, annoyance, or unrest. And we will look at some cases and determine where we really draw the line on these things. The most common example given of free speech, limits on free speech, are not yelling fire in a crowded theater, right? So if the theater's not on fire and I yell fire, what's likely to happen? People are going to try to rush out of the theater, right, to save themselves. And they might put other people in danger, okay? Now, if I yell fire in a crowded theater and there is a fire, that's okay. So why do we ban these types of speech? The concept of free speech is supposed to result in an exchange of ideas. We don't want to limit somebody from being able to exchange ideas, And there's no real benefits, and this type of speech is not part of this exchange of ideas. So the government can limit the expression of those types of speech depending on manner, time, and place. The void for overbreadth doctrine, though, protects speech. It says that any laws which are written so broadly, right, so where they cover far too much speech, that being afraid of getting in trouble and being prosecuted creates a chilling effect, right? So it essentially discourages people from exercising their freedom of speech. Those are laws that violate the Constitution. All right, the right to privacy. The right to privacy is not specifically in the Constitution. You can't go and look this up, but it's what we call a right that is found in the penumbra of the Constitution. Okay, so it originates from a variety of other amendments that are related to privacy. And we can see the 6 amendments here that this relates from. Okay, so the 1st, 3rd, 4th, 9th, 5th, and 14th amendments. Okay, so I'm going to ask you to make sure that you have read those thoroughly and understand that, as this is a pretty important concept. Okay, from those rights we could sort of derive this concept of a right to privacy. What is the right to privacy? It's the right to be left alone, right? It's the right to not have the government interfering in your personal business. Okay, and we're going to see some interesting cases in this chapter that deal with this. All right, we also have a right to bear arms. This comes from the Second Amendment. For most of history, the Second Amendment is not really something that's examined in the Supreme Court. Generally, when they did reach the Supreme Court, people hadn't made very good arguments. 2001, we sort of have our first decision from the Fifth Circuit. So in the appeals process at the federal level, they're going to first, most cases, as far as an appeal goes, are going to go to a circuit. Okay, there's 13 circuits in the United States. For extra credit, right? You guys remember the rules. You can tell me what circuit Massachusetts is in. Okay. U.S. v. Emerson derives from the Fifth Circuit, and they said people not in the militia can privately possess and bear their own firearms, and that includes firearms suitable as personal individual weapons. Constitution also puts some limits in place that are going to affect how we sentence criminals and the types of punishments they can be sentenced to. The Eighth Amendment has a ban on cruel and unusual punishments. This is kind of interesting because I think that if we asked a lot of people about what they consider to be cruel and unusual punishment, we'd have some disagreement here. But they look at things that are barbaric and things that are disproportionate to the sentence. Okay, so barbaric punishment we consider no longer acceptable in a civilized society. Crucifying someone, burning them at the stake, breaking them on the wheel, drawing and quartering somebody, using the rack and screw, any sort of extreme form of solitary confinement. There's some interesting research that talks about how solitary confinement breaks somebody down psychologically. So these barbaric punishments are not allowed, okay? In 1885, the governor of New York questioned the use of hanging as a method of execution. So we have seen the Eighth Amendment used to discuss different types of the death penalty and types of methods of execution. The legislature appointed a commission to study it, and they said that electrocution was the most humane method. So in 1888, New York replaced hanging with electrocution as a method of execution. I don't know about you guys, but I think hanging is probably less scary as an offender than being electrocuted is. We also talk about whether or not punishments are disproportionate to the crime, and that could be something that makes a punishment a violation of the Eighth Amendment. Okay, so the punishment should fit the crime, it should be proportional. Some cases have looked at things like was giving someone 15 years in prison with hard labor disproportionate for falsifying a public document. In this case, they also took away all of the civil rights of liens. Robinson v. California is a more recent case. The person was given a 90-day sentence for being an addict, not for possession of drugs, not for selling drugs, not for manufacturing them, for being an addict. In this case, they said it's disproportionate because we can't punish somebody for being an addict, okay? Once you're an addict, you're always an addict. We can't punish somebody for something that's not a behavior. So as I mentioned, a lot of times the Eighth Amendment comes up in regards to the death penalty. When we look at proportionality, we do look at this in regards to death sentences. In reality, nobody is sentenced to death for anything in which a person is not killed. So usually these cases are reserved for capital crimes, crimes in which you can be executed, are only crimes in which someone is killed, and it usually has an aggravating circumstance. So in 1977, they ruled that rape was no longer appropriate. The death penalty is no longer appropriate in the case of rape. The death penalty for mentally retarded murderers is also something that we've looked at. Between 1976 and 2001, 35 people who were mentally retarded were executed. Mental retardation has 3 elements in its definition. The person has a substantial intellectual impairment. That impairment impacts their everyday life and is present at birth or during childhood. So we have some cases that have looked at whether or not it's appropriate to execute people who are mentally retarded. And we're going to look at that landmark case. But today you can no longer execute people who are mentally retarded. You can also no longer execute people who are juveniles under the age of 18 at the time they committed their offense. Okay, and that's a much more recent ruling from 2005, and we'll talk about that case as well in class. So executing juveniles begins in 1642, starts here in Massachusetts and Plymouth County, where they hanged 16-year-old Thomas Granger for bestiality with a cow and a horse. If you don't know what bestiality is, take a minute to Google it, and in fact, whenever you come across a word that you're not sure what it means, make sure you look it up. Up until 2003, about 1 execution took place per year for somebody who was a juvenile murderer. Oftentimes the people were not executed while they were still a juvenile. They were adults by the time they were executed. In 2003, Oklahoma executed Scott Haynes. He had killed 2 people during a carjacking. He dropped out of school in the 7th grade after he had failed 6th grade 3 times. His father helped him get a job so that he could steal stuff that his father would fence. Before the carjacking, he had not committed a violent crime. And months before his Supreme Court case was refused, 4 Supreme Court justices said the death penalty for juveniles is a shameful practice. So the death penalty is barbaric if it's for something more, if it is something more than instantaneous and painless, and it cannot involve unnecessary mutilation of the body. We've been looking at lethal injection, the courts have, in determining whether or not that's considered cruel and unusual. The death penalty is only allowed for people who are not mentally retarded, for people who are 18 at the time they commit the crime, at least 18, and it is only appropriate for people who have committed a murder. We also sometimes have people sentenced to imprisonment for periods of time that seem disproportionate. But proportionality doesn't necessarily apply to prison sentences. 1983, there's a case where Hellman's convicted of 6 nonviolent felonies. He'd been convicted of these in 1975. He had 3 third-degree burglaries. He had obtained money under false pretenses, grand larceny. He had a 3rd DUI offense. And this is barely a majority opinion in this case. 3 strikes you're out. Legislation has been ruled constitutional. These are very controversial. They do not work, and they often result. California has a really terrible 3 strikes law that is actually very costly to the state and doesn't really address the actual issue these laws are meant to address. They're pretty popular, though. It's got a nice catchy phrase and a simple solution. That's it. 3rd time you've got a felony conviction, you're out of here. And they're developed in the wake of the polyclass abduction and murder. We also have mandatory minimum sentences. So judges here have non-discretionary minimum prison time that they have to give to certain offenders. Non-discretionary means the judge cannot change that sentence. These could include anything from a determinate sentence where the length of the sentence is determined by the seriousness of the offense, and it's determined in advance of the crime, and the judge cannot change that sentence. They also include sentencing guidelines, which in the past were mandatory, but have since been ruled to be advisory. One of the other rights in the Constitution that places limits on criminal law, mostly procedural law, is the right to a jury by trial, right to a jury trial. Up until 2000, the Supreme Court really took a hands-off approach to sentencing procedures. They let judges and state legislatures deal with how sentences were imposed. And then they started getting involved in some cases that addressed this general topic. So New Jersey had a hate crime statute that extended punishment for 10 to 20 years. So if the judge found by a preponderance of the evidence, right, if you guys remember, that means more than 50% of the evidence, that the defendant committed a crime with the purpose to intimidate somebody based on race, color, gender, handicap, sexual orientation, or ethnicity, they would get this sentencing enhancement. Okay, and that's what hate crime statutes do. They, the person gets punished first under the law that they broke, and then if they can prove that the crime was motivated by hatred towards one of these, or intimidation of one of these protected classes, that they get a sentencing enhancement. Okay. They argued here that racial purpose was an element that needs to be proven beyond a reasonable doubt. So whenever we look at a case that increases punishment, all those elements cannot be proven by preponderance of the evidence. It has to be proven, submitted to a jury, and proven beyond a reasonable doubt. And here we've got a little summary of this. So hopefully these, this general content makes sense to you. In the in-class session, please come prepared with these notes. Make sure you have read the entire chapter and the cases, and we're going to discuss how do these laws, how do these limitations actually apply, or how do they play out in actual cases.